said so.
So the Independence Institute, along with some others, have worked on this court case against the laws that Hickenlooper signed on gun bans and universal background checks. And this man here, you know him, you love him, you see him on CIO way too often, represented the sheriffs in that case. Dave Kopel, thanks for being with us.
Thank you for having me.
All right, I got to be honest. When the verdict came back in this case, it was a gut punch in that we didn't do well. But you kept reminding me that this was the first step in what was certain to be a really long process, and this isn't over.
Oh, that's right. And I think everybody, all the lawyers on all sides of the case understood that, of course, the trial in the district court, that's a very important thing, but that the final decision is going to be made by the 10th Circuit, or perhaps the Federal Court of Appeals that covers Colorado and our adjacent states, or perhaps by the Supreme Court if they considered a interesting enough case to take.
For those who aren't following this at home, we knew that 2013 had these gun laws that shook the whole state, ended up with 3 state legislators losing their job, and all the sheriffs, all the elected sheriffs coming out against these laws in a position paper when it was going through. Several of these sheriffs, majority of them, joined on to this suit to say these laws were unconstitutional. The judge in this case whittled that down, saying only these folks have standing. So there were a handful of sheriffs that we worked with. What was the basis of the case? Let's start with, there were 2 issues. Let's start with a gun ban first. What was
the magazine ban, to be
ban?
technical, which
Yes.
actually does have the effect of banning several popular models of guns for which there are no small magazines available.
We argued what? And she didn't buy it.
We argued, first of all, and the reason we had 55 of the state's elected sheriffs as plaintiffs in this case, Democrats and Republicans, rural, urban, most of the metro sheriffs, for example, including, say, Doug Darr, the Democratic sheriff of Adams County, was because we didn't take this "what part of shall not be infringed don't you understand" argument and say that any gun control is unconstitutional. In fact, we always said throughout the case, we're not making any legal argument against there being background checks on the actual private sale of firearms. But we are saying is House Bill 1229, the Bloomberg-written bill, which was enacted in 2013, is completely defective. It sets up a terrible system, supposedly for background checks, that's impossible in practice for many people to comply with. And on top of that, it goes way too far, because besides covering simply actually buying or selling a gun, it also covers loaning or sharing guns with your friends. So if you're a rancher and you want to give one of your ranch's guns to a hand, and he needs to go out into the fields for several weeks during calving season to protect the stock from coyotes and other predators, you've got to drive all the way to some gun store to give him the gun and process that transaction as if he were buying a gun from the store.
Assuming the gun store would even do this, there's nothing that says they have to, and it's a loss for them, and they can only charge $10. So not every gun store was even providing this service.
Oh, most of them don't, because you're right, the fee is capped at $10, and the actual fee that would make stores willing to do it based on other states and previous experience in Colorado is about $35 to $50. And then, by the way, when calving season's over and the ranch hand wants to give the gun back to the ranch owner, they got to go back to the store and do it again. And that's the reason, as we showed at trial, the fiscal notes, that's the legislative from the legislature itself, where they budgeted for how many more background checks are we going to have, how many people are we going to have to hire at the Colorado Bureau of Investigation to do this. The bill the legislature passed was premised on the official legislative records, that every year there are going to be 200,000 additional checks on private sales. And yet, as we showed at trial, the number of checks on private sales has actually declined because this law is so badly written and dysfunctional.
All right, so let me see if I've got this right. When arguing this case in federal court, it was your position, and you argued this, that we're agnostic when it comes to the idea of universal background checks. That's not what we're arguing here. We're arguing that this system is unworkable, that it cannot work, there cannot be the full compliance, and you gave example after example, and I was there for a lot of the expert testimony, which was amazing to listen to. The judge in this case said, we don't agree with you. Her reasoning was what?
Well, her reasoning on this particular point we made is not, and we didn't say it's dysfunctional in theory. Here's why it might be dysfunctional. We showed it was dysfunctional, and the evidence that shows how background checks declined instead of increasing by 200,000, that you moved backwards from your goal. That's how bad the law was. You want to go here, and the law moves you the other way. She essentially brushed past that in her decision and didn't mention the data and said, oh, that's just a policy argument or something like that, referring to it fairly obliquely. And the information we provided came from the Colorado Bureau of Investigation itself. It's their data.
The other side of this case was on the magazine ban. And as you said, there are a lot of guns now which have become inoperative. If you want to buy a
Springfield Armory 9mm.
Yeah, a Springfield 9mm, they don't have a 15-round magazine. They only have a 17-round magazine. So you can buy the gun, which does you no good because there is no magazine to make it work. You've banned the gun. And your argument, which was interesting, said it's not that you can't ban, the government doesn't have the right to ban certain magazines, but the decision that you were involved with at the Supreme Court, the Heller case, was pretty laid out and said these types of guns are okay, so therefore the magazines must be okay. What was that reasoning?
Well, what the Supreme Court said in Heller, the way we read the case, and based on the literal language, what they actually said, was that the Second Amendment protects arms that are typically possessed by law-abiding citizens for lawful purposes, and that are in common use. And so our view is that you can certainly have regulation of those kinds of arms, but you can't have an absolute prohibition on common arms. And arms includes not just a firearm itself. It obviously, as court decisions have held, it includes ammunition, because your gun doesn't do you much good if you don't have a Second Amendment right to ammunition. And likewise for magazines, which have, for hundreds of years, been an essential component of a functioning firearm. You can't completely prohibit those that are common. Could you ban a 100-round magazine? Our argument was maybe you can, because that's not common. That's not in common use. But as even the court recognized and said, these are owned by the tens of millions by law-abiding American citizens.
Talk about, Glock makes the Glock 17, and so many guns now have 17 to 20 round magazines for handguns. You think of the most popular rifle, the AR-15, and the most common magazine is a 30-round magazine for that. These seem to be common usage, and everyone has these that has an AR.
Right, and the court did not agree with that argument. In fact, the court actually, in a footnote, went out of its way to say it would be okay to outlaw the AR-15 rifle. That's the most popular rifle in the history of the United States. Probably 5 million of them currently in the hands of law-abiding American citizens, and it is a rifle that, just like tens of millions of other rifles since the late 19th century, is a semi-automatic, which means you press the trigger once and you get one bullet. It's not a machine gun. And yet she, without any prompting, very spontaneously said it would be okay to ban the AR-15 rifle. And so
incredible.
With that approach, of course, you can ban lots of magazines too, even the ones in the common sizes of smaller than 20 or 30 rounds.
In the same way that the background check is unworkable and it's not working, it's falling apart, the magazine ban is even more so. Since we've been under this law for an entire year now, how many arrests or citations have there been for people either purchasing or transferring, giving it to somebody, a magazine that holds more than 15 rounds?
As far as we know, there has been zero enforcement of either laws. No arrests, no prosecutions, no nothing. So when
is that just the sheriff's departments? Because some of them said they'll try to enforce it, some say we can't. What about police departments? And
sheriff's offices, by the way, not departments.
Yes.
They are not a department of the county government. They're independent. When the repeal bills were being debated in the legislature earlier this year, that information came up, and all of the Colorado law enforcement sources could find no evidence anywhere of any arrest or enforcement for either of these bills.
When this whole thing started, we hoped for a very speedy trial, and I got a sense from the AG's office that they wanted to get this going as well. When you got into the meat of this trial, the briefs started going back and forth, the motions going back and forth, and those are all available at the website
coloradoguncase.org.
coloradoguncase.org, if you want to see all the legal maneuvering. Tell me a little bit about the experience working with the AG's office, and you're fighting that office. You have to work with them as lawyers do. How did they feel about this case?
Oh, I have no idea what their interior feelings.
Give me your sense.
I would not characterize negatively any lawyer on the other side of something. I would say they worked very hard and vigorously to defend their client, who was Governor Hickenlooper.
Some of these briefs got my attention. It seemed as though the AG's office was not very friendly to gun owners or to the idea of gun ownership.
Well, I guess I'd agree with that in terms of some of the stances they took. For example, a few weeks before trial in March, both sides filed their pretrial briefs with their big legal arguments and all that. The position that the Attorney General took on behalf of the governor was that actually it would be perfectly legal for the government to completely prohibit all private sales of firearms. And that's very expressly stated in their brief. And so the fact that they're allowing private sales to take place at all under whatever system is, after all, rather nice of them in the first place, generous.
So the AG's office basically says, hey, government is allowing these private sales, and they don't even have to do that. So to be able to have background checks, that's certainly within it.
Yeah, and by the way,
that seems pretty extreme to me.
Well, and by the way, we think most our clients have different views, but a lot of them think, yeah, background checks are perfectly fine. It's this dysfunctional system where you're supposed to get a background check, but you can't in practice.
All right, less than a minute. Where does it go from here? As we knew, if this went our way, we'd be very happy, but we would know it was the first step in a long journey. What's next?
We will be soon filing the notice of appeal with the 10th Circuit Court of Appeals, and that will start the appellate case going. The briefing in that is likely to last a process of months. It's not uncommon for once a case has been fully briefed and maybe had oral argument in the 10th Circuit, that the circuit often takes around many months or a year to issue a decision.
So those people who say, well, now it's decided, you see, Hickenlooper was right that this was legal.
Well,
time will tell?
Time will tell. Having written the law school textbook on the subject, I'd say if you follow the Supreme Court, it's not legal.
Dave Kopel, thank you. Thank you. Tell a friend about the Independence Institute. We'll see you next week.